Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
Donna Adelson has gotten herself into a bit of a pickle, and it's definitely not kosher. The meddlesome family matriarch has lived for 3/4 of a century, and all that life has come down to this one moment. She likely never envisioned her retirement days present and in custody, and her golden nights in a concrete cohabitation. The good news is she has made a couple of new friends, but that's a very boring story for another time. This sweet old lady from Florida may now be facing her new forever home, but right now she's facing a judge with a face like this. She's hoping Judge Stephen Everett and a cast of jurors won't be quite as judgy as she used to be on the outside. Hers is a tale of unchecked entitlement, overpowering arrogance, and a grandma who just can't quit while she's ahead. So order yourself something nice from the commissary and join us, because this is Absolutely Criminal. If you're unfamiliar with the whole Adelson affair, trust us when we say it's a rabbit hole you're going to want to dive down. Try starting with the playlist currently on screen, and be sure to like and subscribe if you don't want to miss the next chapter. September 2nd, 2025, in Leon County, Florida, began with Donna's defense. Chief Assistant State Attorney Georgia Cappleman and her crew had rested their case before the weekend, and it was time for the other side to defend a client only a lawyer could love. The unenviable task fell to attorneys Jackie Fulford and Josh Zellman, and they began bright and early in the morning. By early afternoon, the morning felt like yesterday, as we all watched together as the two people-shaped blobs way over there in the corner were definitely doing some things. The jail surveillance recording and defense exhibit depicted their client at a jail dorm table interacting with jailhouse informant Drina Bernhard. For nearly an hour, it was unclear exactly what Zellman and friends hoped it would show, but the eyelids of the viewers at home, and undoubtedly the jurors, grew heavy. When the detective testifying about the tape was dismissed from the stand, it looked like the best day of his life. Then, mercifully for all of us, Judge Stephen Everett ended the day hours early in order to give the defense attorneys time to consult with Donna about whether or not she would testify. That will be important later. Our jaws were left sore from yawning and our heads tender from scratching. But what happened on Tuesday, September 3rd, made our jaws drop to the floor and left our heads dizzy with disbelief. And as the day went on, the more we began to question our own reality. An early morning witness was a Tallahassee family law attorney.
My name is Linda Bailey.
Her questioning began fairly benignly as she proudly detailed her background and certifications.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988.
Okay.
With honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I am board certified in marital and family law, and what that requires is an application that's about 3/4 of an inch thick.
The woman who represented Wendy Adelson in her deadly divorce from Dan was ultimately called to detail the contentious case and tell us how not contentious it was.
Did Wendy Adelson and Mr. Markell have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out on themselves, by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing.
Yes, my understanding is they worked out a 50-50 arrangement.
Wendy Adelson initiated this dissolution. Did the pleadings indicate that she was trying to prevent Mr. Markell from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markell from having substantial time sharing.
Hang on a minute, we hear you saying. Yes, we know you thought the divorce between Dan Markell and the wily Wendy was not only contentious, it was murder fuel. Well, you've got another think coming, and Linda will explain by telling you what a controlling jerk the murder victim was.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markell's motion to dismiss the petition for relocation, and then he had filed a motion to enforce life as he would have liked to have seen it, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something, and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by court or even put into any sort of formal document.
Markell was mean and frivolous, Bailey said, but Wendy was wonderful, and the divorce was still an amicable affair, not contentious.
My understanding is before the hearing finished, Wendy essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Wendy was a capitulator and a right waiver. Thanks to her, the problem was resolved, just not in the way you've always thought. Stop it.
Did Wendy Adelson and Mr. Markell resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendy waived alimony. They adjudicated child support. They put into place a parenting plan.
And just in case you forgot, it was so not contentious.
Would it be your opinion that this case was in any way unusual or highly contentious?
No, to the contrary, it was settled amicably, and everybody was moving on with their lives.
And quickly?
Yes.
Now, on to Mama Donna's completely normal and healthy involvement in her daughter's divorce. Trust Linda, it happens all the time.
Did you find anything unusual about my client Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
Wendy did file a few uncontentious motions, however. Someone had to restore order to the non-chaos. There was that matter of the $80,000, and she was its rightful owner.
Wendy filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so dollars. I think there was some question whether you paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially, is what he said. And that is not legally, I don't think it was a very strong legal position.
That's right. The man who would be brutally shot in his driveway and left to die added another completely ridiculous argument to the record. Still, most everyone was compliant and ecstatic with the results. The defense expert went on to testify that the only person really angry with Dan Markel was the defendant. That's the kind of 4D chess strategy we can get behind.
Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Or is it possible to undo this? And then Wendy responded, I think at the end of that, Mom, I'm at peace. I'm good. And then they dropped off. There was no more communication.
Bailey went on to detail the next demand Dan made of Wendy. He wanted to make decisions for his children, or something stupid like that.
Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested.
Whatever his complaints were, Donna Adelson came to terms with the fact that Wendy and the grandkids would not be flying south for the winter, or any season for that matter. Dan had won, and she was fine with it. Everything just fine.
From your review of the emails and the pleadings, did it appear my client accepted that Wendy was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendy waived her right to appeal that.
Everything was so amazingly fine, in fact, that the family planned to offer him $1 million to let the grandbabies relocate southward, which was also fine. Either way, Donna Adelson was nothing if not super chill.
Would there be anything improper with Wendy or her family through Wendy offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate.
Thus far, Linda Bailey had an interesting stint on the stand, but she was apparently just warming up. Remember that nickname Wendy gave Dan? Ostensibly to make him seem less threatening. We were all wrong about what the name meant, even Prosecutor Georgia Cappleman. We all hoped she was writing this down. Spoiler alert, she was.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
When the defense had concluded, Georgia rose from her seat, carrying a binder and pink highlighter as she strolled casually up to the microphone. She undoubtedly wanted to learn from her mistakes and note them on her legal pad.
What is it you were asked to do in this case?
Nope, I was wrong. But finally, someone asked what we had been thinking all morning. She continued, her hair very slightly out of place, apparently from tugging it in frustration as she waited to cross-examine the witness.
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world? Do you agree with that? Do you agree with that?
Ms. Cappleman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree.
Georgia took a moment to compose herself, and then continued. Notice as she appears to intentionally use the word gibberish twice, a callback that will come to haunt the fellow attorney on the stand.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that. You can't agree with it. Strike the question.
The previous question stricken from the record, Cappleman then got down to brass tacks, and she brilliantly extracted the answer she needed to hammer home her point.
Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey.
Right.
To that person, it was a reason to commit suicide, right?
Apparently so.
The prosecutor was cooking, and the witness was nearly cooked. Now to drive home another point and return all the gibberish to sender.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
Depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Georgia Cappleman's parting shots seemed to land more softly than the rest, but the impact felt the deepest as she reminded us all of what and who this case is really all about, clearly.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it can happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
Would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves on a public record. He would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off. So
that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
Now came the time for Donna Adelson to decide whether or not to testify. Despite having extra hours set aside by the judge to discuss this with their client, the defense seemed ill-prepared. It was as if a student had all weekend to complete their homework assignment and crammed with only 1 hour left before school Monday morning. Judge Everett appeared displeased.
As to the other matter concerning whether Mrs. Adelson will testify as a part of a defense case in chief, Ms. Zolman, were you able to speak with her as to a final decision?
I'll allow. The short answer is we were allowed 20 minutes during the lunch break to speak with Miss Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or exhibit the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defense in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not ample time to discuss with her what is actually coming in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision of whether she is going to testify or exercise her right to remain silent.
5 minutes later.
We are respectfully requesting that the court hear allow Miss Adelson to participate at sidebar, as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
Please approach. We are not going to do this for very long.
So the sidebar happened, a break was taken, and coverage resumed as if nothing ever happened. We were momentarily left in the dark by the silent sidebar. So another lawyer was called to the stand. This time, the attorney representing Charlie Adelson along with Dan Rashbaum during his trial. She explains away the one-way Vietnam tickets under direct examination and then on cross by Sarah Catherine Dugan.
During that time period when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yes. Can you tell us what those were?
She had made numerous statements about terminating her life if her son, Charlie Adelson, was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting is putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
On November 6th, her son was convicted, did you speak with her after that specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going,
Okay.
and it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
Let us know in the comments whether or not you think her explanation is plausible. All right, let's get back to it. They hoped he'd forgotten, but it was time to pay the piper and put up or shut up. Would Donna take the stand or rightfully remain silent?
At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand that.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss, or have you been able to discuss with your attorneys, the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I know I have to choose. I was hoping that we have some time to speak to my jury.
This has already been discussed, ma'am. What is your choice?
Judge, since I was handling with the prior witnesses while Miss Fulford was speaking with Miss Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
That will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
5 minutes later. The Honorable Stephen Everett wants an answer from the dishonorable Donna Adelson, and he really, really means it this time.
Zellment, Miss Fulford, Mrs. Adelson, the extra time that you have been provided, that has come to a conclusion.
The time has come. They ignore him. He reminds them.
We are not finished with the colloquy quite yet.
They continue to ignore him. He gently prods them.
I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on.
It's really happening. Donna has an answer.
Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Sorry, everyone. Closing arguments are to follow jury instructions on Wednesday, September 4th. Then Donna's fate will rest with the jury. For Absolutely Criminal, I'm Tiffy reminding you to make sure you ended your phone call, stop detailing your plans in texts and email, and let the darkness come alive.